The Civil Code of Lower Canada came into force in Lower Canada on 1 August 1866 and continued to be in effect in Quebec until its repeal on 1 January 1994. The code was based on the Napoleonic Code and replaced a mixture of French law and English law which had arisen in Lower Canada since the creation of the province of Quebec in 1763. Before the Code, French colonial era from 1608 to 1664. The first colonists of New France followed the customary law in effect for their province of origin in France. In 1664, the King of France decreed in Article 33 of the decree establishing the French West India Company that the Coutume de Paris would serve as the main source of law throughout New France. Later, authorities went on to add le droit français de la métropole, that is, French law. This included royal decrees and ordinances, canon law relating to marriages, and Roman law relating to obligations, e.g., contracts and torts. Also in force were the ordinances issued by royal intendants and the orders and judgments handed down by the Conseil supérieur. The royal intendant was responsible for administering justice in the colony, and lawyers were barred from practicing in the colony. Most disputes were resolved by local notaries or local parish priests through arbitration in a manner much as had been done in ancient Rome. While the reliance on feudal French law meant that New France was divided into fiefs, the feudal lords were not entitled to the same judicial discretion in New France as they had in France, as it was, all criminal jurisdiction went to the intendant. Therefore, while the custom of Paris was the law of New France, there were few resources available for colonists to actually enforce that law. Under the British Empire following France's relinquishment of Canada in favour of Guadeloupe in the Treaty of Paris, Canada came under British law. However, the seigneurial system of land tenure continued to be applied uniformly throughout the province. In 1774, as a result of a ruling by the British courts in Campbell v. Hole about the status of legal systems found in acquired territories, the British Parliament passed the Quebec Act, which preserved French civil law for private law while keeping and reserving English common law for public law, including criminal prosecution. As a result, modern-day Quebec is now one of only a handful of bijuridical jurisdictions in the world where two legal systems coexist. The Quebec Act was opposed by the English minority who believed that British citizens should be governed by English law. The Constitutional Act of 1791 resolved the dispute through the creation of Upper Canada west of the Ottawa River and Lower Canada around the St. Lawrence River. The need for codification. The practice of civil law in Lower Canada became quite complex by the middle of the 19th century. Because of the multiple sources of law that needed to be drawn upon, most only available in French. As identified by René-Édouard Caron, the law of the land included the Coutume de Paris as it was in 1663. During 1663 to 1759, edicts and ordinances of the French crown that applied to Canada. During 1663 to 1759, ordinances of the Conseil supérieur, laws, edicts and ordinances issued by the French crown for France that were registered with the Conseil supérieur, statutes of the British Parliament passed since the conquest for Canada, or which specifically named Canada. During 1759 to 1764, laws passed by the British military government prior to the Treaty of Paris. During 1764 to 1791, laws are passed by the Legislative Council of Lower Canada. Provincial Statutes of Lower Canada, 1791 to 1840. Ordinances of the Special Council of Lower Canada, 1838 to 1841. From 1840, acts passed by the Parliament of the Province of Canada applicable to Lower Canada. English criminal laws as they existed at the passage of the Quebec Act 1774 as amended, for matters not treated in the above categories. Pre-revolutionary French legal writers, such as Robert Joseph Pothier, Domet, and Angers, Canadian legal writers, such as Desailly, Crémazie, Lafontaine, and Bonner. Case law incorporating French case law and judgments published in Canadian law reports. English public law applicable throughout the British Empire affecting the rights of British subjects. In 1859, Désiré Girouard noted, "Creation." In 1857, the Legislative Assembly of the Province of Canada passed an act respecting the codification of the laws of Lower Canada relative to civil matters and procedure, to authorize the codification of the civil law then currently in force in Lower Canada. The Act's preamble declared, "Whereas the laws of Lower Canada in civil matters are mainly those which, at the time of the cession of the country to the British Crown, were in force in that part of France then governed by the custom of Paris, modified by the provincial statutes, or by the introduction of portions of the law of England in peculiar cases, and it therefore happens, that the great body of the laws, in that division of the province, exist only in a language which is not the mother tongue of the inhabitants thereof of British origin, while other portions are not to be found in the mother tongue of those of French origin, and whereas the laws and customs in force in France, at the period above mentioned, have there been altered and reduced to one general code, so that the old laws still in force in Lower Canada are no longer reprinted or commented upon in France, and it is becoming more and more difficult to obtain copies of them, or of the commentaries upon them, and whereas the reasons aforesaid, and the great advantages which have resulted from codification, as well in France as in the state of Louisiana, and other places, render it manifestly expedient to provide for the codification of the civil laws of Lower Canada. The Act authorized the creation of a Codification Commission, which consisted of 3 commissioners and 2 secretaries, all drawn from the Bar of Lower Canada. The Act authorizing the Code's adoption received royal assent on 18 September 1865, and it was proclaimed in force on 1 August 1866. The Commission was also charged with the codification of the laws of civil procedure, and the Act authorizing the adoption of the Code of Civil Procedure of Lower Canada received royal assent on 15 August 1866, and came into force on 28 June 1867. The Code was generally greeted with satisfaction. As Thomas McCord noted in his 1867 edition of the Code, layout, the Code consisted of 4 books. Book first, of persons. Book second, of property, of ownership, and of its different modifications. Book third, of the acquisition and exercise of rights of property. Book fourth, commercial law. The provisions of the Code were drawn from several sources, including the Napoleonic Code of 1804, the Louisiana Civil Code of 1825, the writings of Robert Joseph Pothier on pre-revolutionary French jurisprudence, writings of contemporary commentators regarding the Napoleonic Code, the Field Code movement in New York, the law of the Swiss Canton de Vaud. The codification resulted in many parts of the French civil law being available in English for the first time, as Thomas McCord related later. Innovation. While the 1804 French Civil Code's framework was used in drafting the CCLC, the commissioners had to adapt its provisions to conform to the legal situation in Lower Canada by deleting those provisions that were new law and thus not in force in Lower Canada, adding to the Code those laws particular to Lower Canada. In addition, they proposed 217 resolutions for changes to the law, which were accepted by the legislature with only minor modifications. As Thomas Jean-Jacques Loranger observed in his 1873 work, Commentaire sur le Code civil du Bar Canada, 4 main objects stand out in the new legislation, reflect its spirit and summarize its general design. The drafters of the Code have based their reforms upon 4 fundamental principles which are the very foundation of their work. These principles are unlimited liberty of contracting, within the bounds of morality and public order, and, as sanction, the irrevocability of contracts except in accordance with the stipulations of the original agreement, the absolute right of the owner to deal with movable property, the conveyance of a movable property and the perfecting of the contract by consent alone, the introduction of uniformity into the law by the coordination of its different branches, the application of the same principle to analogous cases, a strict deduction of principles in cases where the law is silent or contradictory, and the substitution of an absolute legislation for an arbitrary one, in other words, the substitution of a positive jurisdiction for the discretionary power of the courts, the simplifying of the rules which give rise to rights created by law, and which govern the legal transmission of property in the absence of any formal disposition thereof, the forms of contracts, and the creation as well as the exercise of legal rights. Finally, provision for giving publicity to charges which, if concealed, might cause prejudice both to third persons and to the contracting parties. Each of the amendments which we have enumerated will be found to fall, by a natural affinity, into one of these four classes. There were significant reforms to the previous French law. Consent alone was now sufficient to convey the ownership of property without any delivery. Leasing was abolished as a cause of nullity in contracts between persons of major age. Unlike the 1804 French Civil Code, with its revolutionary ideals, the Civil Code of Lower Canada reflected the conservative, family-oriented values of the largely rural society of 19th-century Quebec, as well as the economic liberalism of the burgeoning commercial and industrial elites concentrated in Montreal. In structure and style, the code reflected the 1804 French Code very closely. Nevertheless, it rejected major elements of the French Code which were new law and socially unacceptable to most acute COIs, while maintaining elements of the pre-revolutionary French law. Although most of the original draft of the code was done in French, all of Book 4th and most of Book 3rd were originally drafted in English. In order to deal with any potential conflicts between the French and English texts, Article 2615 of the Code stated, 2615. If in any article of this code founded on the laws existing at the time of its promulgation, there be a difference between the English and French texts, that version shall prevail which is most consistent with the provisions of the existing laws on which the article is founded, and if there be any such difference in an article changing the existing laws, that version shall prevail which is most consistent with the intention of the article, and the ordinary rules of legal interpretation shall apply in determining such intention. In 1922, Francis Alexander Anglin, in addressing the Junior Bar of Quebec on the impact of the code, observed, "Replacement. From 1888 to 1979, the code was amended to reflect the various social and commercial changes occurring within Quebec society. In 1890, the Parliament of Canada ousted Articles 2279-2354 of the Code with the passage of the Bills of Exchange Act. Work commenced in 1955 on the revision of the Civil Code of Lower Canada, which eventually led to the passing of a new civil code by the National Assembly of Quebec on 18 December 1991, which came into force as the Civil Code of Quebec on 1 January 1994. The repeal of the CCLC did not affect those provisions that affected areas within federal jurisdiction, which continued to be in force in Quebec until they were finally repealed by the Parliament of Canada on 1 June 2001. Bibliography 41, 1865. CO. Beauchemin and Valoir. 1866. Retrieved 27 March 2013. The Civil Code of Lower Canada. Together with a synopsis of changes in the law, references to the reports of the commissioners, the authorities as reported by the commissioners, a concordance with the Code Napoleon and the Code de commerce, special references for notaries, clergymen, physicians, merchants, real estate owners, and persons out of Lower Canada, and a complete index. Thomas McCord, 1867. Retrieved 27 March 2013. Charles Camille de Lorimier, Charles Albert Vilbon, La Bibliothèque du Code Civil de la Province de Québec, Cadieu de Roma. Pierre Basile Mignot, Le droit civil canadiens basé sur les répétitions écrites sur le Code civil, de Frédéric Moulin avec revue de la jurisprudence de nos tribunaux, par P.B. Mignot, Conseil de la Reine, Whiteford Terret, Éditeurs. Terret, Éditeur, Wilson and Lafleur, Éditeurs, Montreal. E. Fabre Surveyor, The Civil Law in Quebec and Louisiana. Louisiana Law Review 1. 649-664. Retrieved 1 April 2013. The Civil Code of Quebec. The Encyclopedia of Canada. 1948. Retrieved 28 March 2013. Johnny C. Brierley, Quebec's Civil Law Codification. McGill Law Journal 14. 521-589. Retrieved 1 April 2013. David Howes. From Polydurality to Monodurality. The Transformation of Quebec Law, 1875 to 1929. McGill Law Journal 32. 523-558. Retrieved 1 April 2013. Brian J. Young. The Politics of Codification. The Lower Canadian Civil Code of 1866. McGill Queen's University Press. p. 134. ISBN 0-7735-1235-7. Retrieved 29 March 2013. Nicolas Cassira. See Large Conde chez Trouve-Louve, Outrouvti on le Code Civil du Bar Canada. Les Cahiers de droit 46. 481-518. Retrieved 27 March 2013.